The information in this podcast is not legal advice and should not be construed as such. It is for informational and educational purposes only.
Welcome to Resource Sessions. I'm Gwendolyn Sterk of Sterk Family Law, and we're here today for part 2 of our 2025 new employment-related laws in Illinois. And I'm honored to have Attorney Seth Matus with me today from Workplace Law Partners. Welcome, Seth. How are you?
I'm doing well, Gwen. How are you?
Good. So part 1 was a little intense there about all these changes that are going on and kind of making you think about different perspectives. But there's a whole additional arena of laws that have come into play in 25. Do you feel a little overwhelmed by all of it?
I think so, Gwen. I mean, part two is going to probably be about as intense as part one. I think
Oh,
this
boy.
is one which employers kind of will need to think about a little bit.
Well,
So,
let's start with the Illinois Right to Privacy in the Workplace Act and the amendments that are going into effect. Tell us about
okay.
that.
So let me give you an overview of that law. The Right to Privacy Act started out as a law which basically allowed employees to smoke off the job. That's what it was
Off
originally.
the job, not on.
Off the job, not while working, but basically, if you're smoking and you happen to be a smoker, you were protected under that law. Now, it's evolved over the years. I mean, there was a provision that got put in that talked about employers can't force employees to turn over, say, social media information, a little more modern. But now the law is evolving yet again, and what they are trying to do is to protect people who may be undocumented. And so what this law really does is, the amendments add a lot of protection for, the I-9 process. And I-9, what I'm referring to are when you get a new job, you have to fill out these forms which show that you're authorized to work in the United States. And you would turn over documents, say like a driver's license, a social security card, all those kind of documents. Some years ago, the federal government came out with what they call E-Verify. And E-Verify is a program, it's not mandatory, but employers can choose to enroll in it. And basically, with E-Verify, let's say you get a social security number, you type it into a database, and there is a match or there is a no match that comes back. And in the past, what had happened was that if there was a no match, a lot of times you would not allow that employee to be or applicant to become an employee. Um, so what the amendment does, there's a couple of provisions. When it comes to people who are using E-Verify, it basically says that if you're using that system and then you come back with a preliminary no match notice from Department of Homeland Security, what you have to do as an employer is, first of all, you can't immediately fire that person. You need to let them know that, hey, we've gotten this no match from the Department of Homeland Security. You then need to tell the person that he or she has the ability to contest it and to give that person the information, the contact information for whatever agency where they'd need to go, whether that's the Social Security Administration, Department of Homeland Security, etc. So, and again, you can't fire the person until you get a final, definitive no match from Department of Homeland Security. That's if you use
Wow.
E-Verify. Then, what if you don't?
Right.
If you don't use E-Verify, but you get notice, say, from Social Security Administration, Department of Homeland Security, whatever, that there is a possible issue, same thing. You need to let the employee know that, hey, this government agency is saying that your papers don't match the Social Security number that you provided. Here's what you can do. Employers can't fire the person right away. You need to protect them. And then on top of that, you might have a situation in which you have, again, Homeland Security, Social Security Administration. Every now and then they'll do audits and they will come into an employer and they will go through all the I-9 forms. So what the amendment provides as a third section is that if that happens, you need to let employees know that the feds came in or the state came in and they were looking. And, again, provide them
All the
information.
employees? You gotta tell everybody?
All the employees.
Oh, boy.
All the employees
Oh,
that this
boy.
has happened. So that, again, talking intense, this is the intense part of my presentation, Gwen. Employers
Yeah.
now know about this, but there is a tremendous additional obligation which is placed upon employers. And if it turns out that you fire an employee before you get any of the final notice, that's a discrimination claim.
Okay, I have a question though, because
Yeah.
the I-9s had to be filled out and completed before they start working as a general
Yes.
rule of thumb.
Right.
So that you get the I-9 form after you've made an offer of employment. So
Yes.
let's say that you make an offer of employment, you go through this e-verify system and you still haven't employed them and it came back with a no match. You notify them and they have time to investigate it. Do I have to hold the job open while they're investigating?
Yes. Yes.
But
That would
that could be
be,
a long time.
and Gwen, this is one of the great parts of this law. Yes, this is one of the things, one of the
Yeah.
implications which is arising out of this law. A
Okay.
situation like that could happen.
Could I ask them to do the I-9 before they apply and make sure that they're authorized to work before I make an offer to them?
Well, I think that the problem there is that, it's
Mhm.
sort of like the I-9 comes as a condition of employment.
Right.
You need to give it to them within, I want to say, 3 days, if I remember correctly, of
Right.
them starting employment.
Of starting employment. But could you?
Yes.
I'm trying to be this creative employer out there, and I don't
Yeah.
know. Could you say I'm not going to, until you go through the I-9, I'm not going to make you an offer?
I think that could be possibly problematic there too.
Yeah, I do
So I
too.
think you're
Based
kind
on,
of damned
yeah.
if you do and you're damned if you don't, Glenn. So,
That is really frightening. I would like to defend the people who have to go through US Customs when you tour, you go outside of the country, and if you don't have the appropriate pass, the global entry pass, you're standing in line for 2 hours to get back into your own country, and you have to stand there
yeah.
and verify. But yet people who haven't verified yet we can be obligated to pay them pending their verification, which
Having
may
this,
be months, right?
it could take a long time. You're
Okay.
entirely right.
So
That's
here's my
entirely
next
right, Glenn.
question. So let's say that we hire the individual, we give them the
Mhm.
I-9, they fill it out, comes back that it's not a proper number. So we give them notice, they go out and conduct their investigation, and 6 months have gone by and they come back and they don't have the appropriate documentation. Okay. And we terminate them at that point.
If they don't have it, yeah, then you can terminate them.
What about their benefits?
Their benefits could, you're talking about at the end of that time period?
Mm-hmm.
Yes. Yes. At that point, if you have that final notice, the answer is yes, and they can be terminated at that time.
Let's say they accumulated vacation time. Have to pay them?
Wow.
Yeah.
Yeah. Yeah. I think potentially that could be there. Yes.
I had to pay them
They
for
would have
holidays.
all of the obligations, all of the
Excuse me.
benefits that a normal, documented employee would get will have to be paid to that person too. I
Okay.
think that follows from this law.
So let's say somebody doesn't have their paperwork in order. They
Yeah.
have had a fire at their home. They don't have their passport. They don't have their driver's license. They're still getting their birth certificate. It's not a situation where they're an undocumented individual from not having access into the country. It's simply life events that have caused this, right?
Yes.
We would turn away that person traditionally and say, we're not going to hire you until we can't let you work here until you have your appropriate paperwork. So why is this a carved out exception?
That's something you would have to take up with the General Assembly.
Isn't that
But
very interesting though? I mean,
yeah,
I
it
have a
certainly
friend's
is.
daughter whose house just burned down and they have nothing left. They were luckily out of there, but no paperwork, nothing. So they don't have birth certificates. They don't have some basic stuff, right?
Right,
So
right.
it's just kind of a interesting, how do you flip that side of the coin?
I think that's a fair question. And I don't know that the people who drafted this law really thought about that, but all these questions flow. And here's another question. I mean, again, if certainly under the federal law, there are issues about, employers cannot knowingly employ undocumented people.
Right,
And if you have this situation in which you have this tentative no match, and
right.
then you're taking them for 5 or 6 months, are you knowingly employing someone who is undocumented? I don't know the answer to that, but I think that is a risk on the other side. In complying with state law, you could possibly end up violating federal law.
And one would think federal law would trump,
One would think it would trump.
right?
One would think.
But you don't know. Yeah. Very interesting and very, very confusing. And I think more clarification hopefully will come out on that.
Yeah, yeah, I think you're
But
right.
I think it's this kind of stuff, and I'm speaking from the employer perspective, that makes people throw their hands up and say, it's so much, I can't keep up with it, right? So,
I think that's right. And I mean, I think that what I would say, Gwen, especially for the really small businesses, I mean, the mom and pop shops, I mean, this is why, to some degree, you need to remain engaged. You need to sort of stay connected, say, with the Chamber of Commerce or an employment attorney. I mean, I will plug myself, but
sure.
certainly chambers of commerce. I don't know if it's necessary to join the Society for Human Resources Management, SHRM, but there are organizations out there that do advise employers and especially small businesses of these issues. And
Right.
so that's really, I think, an important part of operating a business. I mean, it's sad to say you'd like to just focus on bringing in revenue, but it's far more complicated than that.
Does this apply to employers of all sizes in Illinois?
Yes,
Wow.
yes. Anyone who is using E-Verify, I mean, I think we all have to fill out I-9s.
Right.
So you're right. Yeah, any size.
Well, it's a little overwhelming, but let's go to the next law and talk about it and see where we end up there. Let's go to
Yeah.
the
Oh,
Illinois
yeah.
Whistleblower Act amendments effective in 25.
Now, so Gwen, with this one, I would say I don't see as sweeping an application of this law.
Okay.
But, I think we kind of all generally know what a whistleblower is. Someone who is reporting some kind of wrongdoing by an employer to a government agency. And that had been for a long time how the Illinois Whistleblower Act read. So now we have these new amendments, and basically what it's doing is expanding employee rights here too. Um, Before, you would be a whistleblower if you had reasonable cause to believe that there was a violation of federal or state law. So again, you need to have reason to believe this, and it
Right.
needed to be a violation of law.
You mean it couldn't be your gut feeling?
Well, reasonable, that was the
Yeah.
difference.
Right.
So now what they say is that you are protected if you have a good faith belief that it's a violation of federal or state law, or it is a issue of public health, safety, or employee safety. So you could have a situation where, again, technically it's not a violation of any federal law, but let's suppose, I don't know, you're worried about employees potentially getting exposed to overhead, electrical field, something like
Right.
that, if you have a good faith belief. And so I'm not saying that anything goes. It's not that. But, if there is, you can point to something that sort of substantiates why you feel the way you feel. And then you report it either to the government agency. And what also is new, if you report it to the employer itself, a supervisor, a manager, you address this concern, that person potentially gets a protection of the Whistleblower Act.
Wow.
And basically, the protection, if you discipline that person, if you discharge that person, you do anything which is called adverse action, anything that would deter a person from doing that, that creates liability.
Well,
So,
you're talking about good faith basis for health. Let's just look
yeah.
back at 2020. I mean, the whole controversy over masks, over, you know, the shot,
Yes,
whether you should get your, immunization, and the whole controversy. I mean, what's good faith? Is it good faith of just your good faith, your belief structure? Because this could be such a broad range, right?
I think you're right, Gwen. And I think that I mean, that's a very good example. I mean, when it comes to COVID, when it comes to vaccination,
Sure.
you could see employers getting it from both directions. I mean, people who believe that vaccination is necessary and, oh gosh, you're allowing this unvaccinated person access, and vice versa.
Right. And vice
No,
versa. So does
yeah,
everybody get to stay their peace and just they're all protected? I mean, what if the lights
if
are too
there's
bright or they make too much sound because there's, the whole controversy over certain types of lighting can affect your health. I mean, when is it a mainstream? Does it have to be a mainstream problem or can it be your own belief structure? These are questions
well,
I have.
I think that okay. Give me a second here. I want to look at just to make sure what it specifically says.
I'm thinking about the electrical connections, the
Yeah,
connectors that are in certain type of fluorescent lightings. Some people say they can hear them buzz. I can't hear them buzz. They don't bother me, but somebody else is bothered
exactly.
by it. So what's good
Exactly.
faith?
I think that's exactly right. And there
And
is
I
no
understand what
definition.
adverse action. Right. It's
Yeah, there
probably
is no
unspoken.
definition
Mhm.
of what good faith belief is.
And practicing law long enough, we can all go to court and comprise and say this is good faith, and it'll be up to a judge or a jury to make that determination. And that's kind of frightening from an employer's perspective.
I think that there is a whole range, again, can, again, something that you see on the web, something that you see in a social media post. Is that going to be enough to create a good faith belief? Who knows? Can you convince a judge? Can you convince a jury? You're absolutely right.
And this is where, judges try to, and I do think that judges try in good faith to be neutral, administrators of the law and enforce it equally. But we can't dismiss the fact that sometimes your background, how your mother raised you, whether she was a hypochondriac or not, could have your perspective over what's a good faith medical condition. Fair enough?
I think that's exactly right.
And
I
that's kind of
mean,
scary. So.
yeah, yeah.
Well, I think that well-intended laws sometimes have these effects because the legal system, unfortunately, with good lawyering, can put it out into an extreme one way or another, and that becomes somewhat of an issue.
No, I mean, not somewhat. It is an issue,
It
and
isn't.
I think it's going to be a huge issue. So,
Well, let's go to the last one and talk about the Freedom of Speech Act.
so this is a new law, Gwen, and this is going to be kind of an interesting one. But basically, what this law is intended to target are mandatory meetings where an employer promotes, you know, anti-unionization. You don't want to become involved in a union, or it's a religious gathering, a proselytization, or a prayer circle, or something like that. Or third, to talk about politics. So there have been some employers who have mandatory meetings to discuss these types of issues. This law now states that employers cannot compel employees to attend those kind of meetings. And, you know, if an employee chooses not to attend, the employer cannot discipline the employee. And so again, this would be the sort of thing if that does happen, the employee could, in theory, sue the employer. Now, there are carve-outs, certainly this doesn't prohibit employers from having all hands meetings to talk about company policies, changes in benefits or rules, any of those sorts of things. But it's those kind of categories, politics, religion, unionization, that get problematic.
Now, what if the meeting starts out as being a case review or a product review meeting, and the subject comes up? Obviously, it is the role of the owner or whoever is in charge of the meeting to shut that down. But I mean, sometimes inevitably it cycles out, right? It circles out, and you have to stop it. Just because something came up in that meeting, if it was not the intended purpose of the meeting, that wouldn't be a problem, would it?
I don't see how that would be a problem. I mean, certainly I suppose you could, people sue all the time, Gwen, you know that, I
Right,
know that.
right.
And so I suppose that you could see that type of claim, but I think this law is pretty clear. I mean, it's meant to apply to meetings which are strictly devoted to that one particular purpose. And certainly if, especially if it's something that's initiated by an employee, I don't see how an employer would create any, have any possible liability.
Right. Well, we've just touched in these last two podcasts on the areas that are changing in 2025. There's a voluminous body of law that already controls.
Yes.
So I think that employers and employees need to understand what that law basically looks like, looking at the employee handbook, looking at insurance options, things of this nature. So I do recommend that people reach out to an employment lawyer, and Seth Matus is certainly somebody that can help you with this. And like you said, you can also reach out to various local organizations, but it's so important that people learn this. It's kind of frightening for an employer from my perspective.
I think that employees really, yeah, you have to be on your toes. And it's not obvious. It is definitely not obvious. So that's the danger.
Yeah, it's a new day. And so I think that having this and having trainings and understanding the importance of it is very important. Well, thanks, Seth, so much for your time today. We really appreciate it.
Of course, Gwen, it's always a pleasure.